Kim Jong-un, the leader of North Korea, has now toughened the law a little bit, where he now orders divorcing couples to labor camps. Both couples will be sent to labor camps for up to 6 months. Under the new rules, both spouses will face imprisonment once the divorce is finalized.
Word to the wise, if any of you are listening to our show and you're thinking about getting divorced in North Korea, you're going to be breaking rocks for a while after that. I'm Raif Palmer. This is Rahul Iyer, and we are here for the I Just Want This Done Divorce podcast. We are loaded for bear. We've got some celeb divorce news, Chance the Rapper, Angelina Jolie, and Brad Pitt. For those of you listening from North Korea, we've got some bad news for those of you getting divorced. And then our topic for today, a legal topic we always cover, is what is a divorce trial? What is it like? We're going to talk about how those work. Then we're going to talk about why is it lately in the trend on social media is the advice for everybody is dump him, divorce him. Why is that going on? We've got a story from Vox talking about this trend and listener questions, as always. Without further ado, tell us about what's going on with Chance. What's the situation now, Rahul?
Chance the Rapper, in our last episode, we had mentioned that they had filed for divorce, him and his spouse, Kristen Corley. It was a very fresh case at the time. You and I had speculated at the time that this may be one of those situations where they've worked out a settlement behind the scenes so as to avoid any sort of public hashing out of issues, dealing, since unless there's a specific reason why a court order has to be sealed, it'll all be part of public record for a large part of it. So to avoid all that public scrutiny, to keep their personal lives private, we speculated that they might have worked out some sort of a settlement or maybe in the process of working it out. So since that episode and now, they have officially been divorced, and the settlement is, of course, at this point private. So we're not really sure what term they had reached, but our presumption was correct that it sounds like they did work out their whole agreement behind the scenes and they are officially divorced. Chance the Rapper is famous rapper from city of Chicago. We are in the city of Chicago, so I think it's one of those where it was a very topical point that came up, and just as fast as it started, it's done.
Yeah, and this is where we've talked about before with divorces with celebs, keeping it out of the public eye and then keeping as much of their settlement terms private as possible. Judges will allow you to hold out the marital settlement agreement or portions of it, like a balance sheet, which show the assets and liabilities and things like that. So savvy lawyers will ask for that to keep as much personal information out of public record as possible. It's likely that what's actual public record is just a very bare bones divorce judgment, which just says these folks are divorced, they have some kids, there's a custody judgment that's joint custody. They've agreed to some general terms on support, probably a very summary document that doesn't say a lot. And that's all by design. We do divorces like that too, where we keep a lot of information out of the public record. And the settlement agreement is a separate document the judge reviews. It's signed by the parties and the details are signed and the court reviews and approves it. But then basically the judge gives it back to you as the lawyer or the parties, and then they keep it separate. Now, the important thing is they have to keep that safe, because if that document disappears, there's really no record of anything. It's like if they have a prenup and they lose the prenup and there are no signed copies, then there's no prenup. So one of the risks of this privacy thing is you really need to keep that thing safe, or it's a mystery as to what was agreed to. Maybe your lawyer keeps a copy, but you can't rely on an attorney to keep your documents because they might go out of business, they might retire, they might die, and 20 years go by and you can't get the document from them. So, and the court won't have it because you've taken it back. So word to the wise, be careful about that stuff, but it is a good way to keep things private. We do recommend it in cases where people are sensitive about having their finances in public and the details about their divorce public.
In that vein, maybe make a copy of it and email it to yourself. Attorney really in this day and age should be emailing you things. I mean, we certainly do to all our clients, so they have an electronic record. But in case your email becomes defunct or you change email addresses, this is probably one of the more important things in your life. You should probably make sure you email yourself a copy so that you have that.
Yeah, I always believe in keeping 2 or 3 digital copies. So it's great to have a physical drive, not just relying on a cloud drive. So you buy one of those portable drives, plug it into your computer, download your important stuff fun there. Unplug it when you don't need it. Keep it there. Keep it in a couple of cloud locations that are secure, and then print one, keep one that's signed and put that in a safety deposit box, or at least a fireproof safe. You can buy those little fireproof safes, keep it somewhere secure, because you never know when you're going to need that document.
Right. You should probably just do this with just general, all of your important documents anyway. Passport, social security, insurance card, just scan, copy, takes 30 seconds. Our cell phones scan things these days. So it doesn't take very long. It's just actually doing it.
I just read this crazy thing on Twitter, which, I'm not sure about the truth of it, but this person posted that in these terrible fires in LA, somebody left their physical Bitcoin wallet. Like it's basically like, think of a hard drive where their Bitcoin stored, and their password was written on a piece of paper. Gone. 100 Bitcoin. That's 100 times currently $92,000 of Bitcoin.
That's $9.2 million.
Just gone. Yeah, be careful about how you keep that stuff, whether it's valuable assets like Bitcoin or your private documents. You got to keep that stuff secure. You never know. So anyway, so next we've got Angelina Jolie and Brad Pitt. Their divorce negotiations have gone on for 8 years. They were married for all of 2 years, from 2014 to 2016. And this is like the nightmare scenario. So the flip side, we talk about how celebs, tend to negotiate things and get divorced in the shadows, so to speak, or they do negotiation and do things through alternative dispute resolution, keep things out of the public eye. Maybe it backfired in this case because the negotiations took 8 years and they finally filed the divorce papers and got divorced. So apparently they reached a settlement after 8 years. Angelina Jolie filed a declaration for uncontested dissolution of her 2-year marriage to Pitt, Superior Court of California in LA on December 30th. The document notes that they both appeared and have entered into a written agreement about property and their marriage rights, including support. The document says she's knowingly giving up her rights to receive spousal support. Probably good, because she's probably loaded to the gills. My understanding also is more than 8 years ago, Angelina filed for divorce. So this is a statement from Jolie's lawyer. For Mr. Pitt, she and the children left all the properties they shared with Mr. Pitt. Since that time, she focused on finding peace and healing for her family. This is a quote from James Simon, Jolie's lawyer. The story here from ABC News. He said, "This is just one part of an ongoing process that started 8 years ago. Frankly, Angelina is exhausted." I would say, expect so. So the interesting thing is they first filed for divorce in September 2016. Now, they must have dismissed the case by agreement. There's no way a court would let this sit for 8 years. In April 2019, a judge declared them legally separated while negotiations on other issues continued. So that took 3 years or 2.5 years. And so I'm not sure if we've talked before on the show about what a judgment for legal separation is, but in Illinois, a judgment for legal separation is a separate judgment, and it really takes similar work as a divorce, and it just means that you're really financially separated. You're still married, but you don't accrue more marital property. So normally when you're married all the way up to the day you're divorced, everything you earn or your spouse earns or purchases is marital property that needs to be divided in the divorce. In a community property state, which California is, and there are only like 8 community property states, what's interesting is the minute you file for divorce, the community is severed and you don't create new community property. We're not California divorce lawyers. There must be some other advantage here of being legally separated, or they wouldn't have bothered. In my estimation, in Illinois, it would be very unusual for somebody to seek legal separation at all, because it takes most of the work of a divorce. It's pretty much the same. Only at a trial, a judge can't divide your property, and the property oddly remains marital, except for the new stuff you get after the judgment for legal separation is entered. So they've been battling over the years, including custody of their children. They had shared business interests, including a winery they had. They had this French estate, apparently. There's a separate case litigation involving this winery. They share 6 children. 3 were adopted by Jolie, later by Brad Pitt. And they have 3 biological children between them. So a source tells ABC News of Jolie she doesn't speak ill of Brad Pitt publicly or privately. She's tried hard to be light after a dark time. Of course, as we've talked about before with celebs, always good business. Never badmouth each other. Don't do it if you're not a star. Still a bad idea to badmouth people, but even more so when so much money and your public image is on the line. So good for them getting this done. Details, of course, are confidential. But the interesting thing here is this tortured path. I believe I read somewhere that they had a prenup, which one would think would make things easier. But in this case, there was enough stuff here that was jointly owned. I think that they had a lot of issues. And this just shows that even a 2-year marriage can create a divorce that takes even longer than the marriage itself. I've seen cases in Cook County take longer than the original marriage.
Even with prenups.
So prenups are normally really good insurance, but there are people that will challenge them just to try to get leverage in a case. So interesting story, and good for them finally getting it resolved.
The other thought I had, Raif, on that one was that I almost wonder if the article just does not know, or the author of the article doesn't distinguish between a legal separation and having a bifurcated divorce, where the judge in California oftentimes, I believe, or I understand it to be the case, that they will oftentimes bifurcate the case, so you're divorced, and then they will go ahead and discuss divisions of property. And so I almost wonder if that's something that happened, that the author of the article maybe misunderstood to be a legal separation. I don't know.
I think you're right, because I'm Googling it. It appears that they requested a bifurcated judgment and that person misinterpreted an ABC News. And so essentially what this means, folks, and it's not a waste of time that we talked about the legal separation. They actually got divorced, as they're no longer husband and wife in that judgment, but they reserved these other issues to be resolved, as Rahul's explaining. So what you find, this is extremely rare in Illinois. I haven't done one bifurcated divorce. I've heard them only being denied, that people want to get divorced, meaning they don't want to accrue more marital property and they want to be able to marry somebody else. But judges will say the mentality among courts in our area is, what's the point? I need to hold your feet to the fire.
Right. And I've been a part of a couple of those bifurcations. They happened before I got into the case, but both times it was because one of the parties is really on deathbed. You need to be close to dying, where a judge says, if you were to pass away in the middle of a divorce proceeding, then by operation of law, your soon to be ex-spouse, but still your current spouse, will take your estate by virtue of probate or by virtue of any will you might have or something that, didn't contemplate a divorce. And so to avoid that from happening, the judges may bifurcate the case, but you need to be unfortunately dying like next week or something to that effect for something like that to happen, because otherwise, like you said, extremely rare and probably not going to happen just because you want to be divorced.
Yeah, and courts, they just figure, well, if you want it so bad, let's then get it done. I'm not going to make it life easy on you. So maybe the California courts have their own way of doing things, and they may have their own rationale. I'm sure. It's extremely rare in our area to get bifurcated divorces done.
Right. And this is very important to highlight that, again, we have a lot of consultations calling us saying, I read that so-and-so got a legal separation before they got divorced. I would like that too. I heard that happened. Well, it's like, don't believe everything you read, because just like this clear example here, there's misinterpretation of what actually happened that's being filtered through and distilled by some reporter, not a lawyer, who is perceiving what may have happened and then further paraphrasing that for public consumption. And so now it's like the telephone game, where the original is no longer what actually happened. And so you want to be sure that you're listening to proper legal sources when you try and determine what you want to do.
And this is something we caution people about when we have consultations, and they'll say, well, my buddy got such and such divorce terms. It'll be like, okay, where was that? Well, it's Florida, or fill in the blank, some other state. And then when was it? Oh, it was 8 years ago. Well, if it was even in Illinois and it was in 2014, that divorce is going to be drastically different than something now, because the child support law was different. The alimony law was different.
The custody laws are different.
Custody laws were different. And so your mileage will vary because the law changes from time to time. And then your states are radically different. Like we've talked about South Carolina, where adultery is like really, really important, and it makes a financial impact in the case. In Illinois, it makes no difference. So that's when it's important to understand that circumstances will differ, and you've got to talk to an experienced divorce lawyer in your area to understand how things work. Not just the state law, not just the stuff you can Google or ChatGPT search, but what is going on the ground in the courthouse with real cases, because it's not a laboratory setting. It's not cut and dried. For example, Illinois maintenance law, there's one reason you can terminate spousal support in Illinois is cohabitation. And if you read the statute, it says living with somebody's a reason on a resident continuing conjugal basis is a valid reason to terminate maintenance. That's lovely, but in practice, judges don't do it. And a divorce lawyer who has experience will be able to tell you, good luck getting your maintenance terminated, even if your ex is living with somebody else and has been there for months. And so those are those little nuances that we know from doing this stuff, that you could chase down a blind alley and run right into a wall at a dead end without, with good intentions if you don't know. So, okay, now I'm dying to know about Kim Jong-un and divorces in North Carolina. Sorry. We just talked about South Carolina. North Korea.
North Korea, a little bit different than North Carolina. So a new article has come out. The article describes the changes to the world of North Korean divorce, so to speak. So Kim Jong-un, the leader of North Korea, has now changed the law there where he essentially toughened the law a little bit, where he now orders divorcing couples to labor camps.
Ouch.
Both couples will be sent to labor camps for up to 6 months, and women potentially face a longer sentence. So the article says the North Korean leader has declared that ending a marriage demonstrates anti-socialist sympathies that warrant punishment. And the article further says, this represents a toughening of existing laws which previously only punished the party seeking the divorce, even in cases of physical abuse. Under the new rules, both spouses will face imprisonment once the divorce is finalized. So essentially, what happens is you go to court, the judge grants you your divorce, and then puts you in cuffs and escorts you to the county labor training camp where you are now going to be living for 6 months. Apparently, the article further says, and this is an article from thestandard.co.uk, in Korea, the act of divorce is not only considered an affront to socialism, but also on the Confucian values that tie into thinking of those in the North and South. My question really was, if you don't like divorce so much, you're the leader. Instead of changing the laws, just outlaw it, as opposed to saying, well, you could do it, but then you're going to go to a camp.
Right. It seems kind of interesting. Well, word to the wise, if any of you are listening to our show and you're thinking about getting divorced in North Korea, you're going to be breaking rocks for a while after that. The good news is you can get divorced. The bad news is you're going to be at a labor camp for X amount of time afterwards. And I'm guessing that's not fun. So, okay.
You got to really not like somebody to say, 6 months of labor camp sounds better than this.
Yeah, like I'm happy to break rocks for 6 months to get divorced.
So if you think you have it bad, think about this.
Oh, man. All right. So moving on to our topic of the day, we're talking about a legal topic, and this is, what is a divorce trial? What is it like? So we're going to have a conversation about what to expect with divorce trials, and now different states are going to have some variation, but by and large, most states are similar to Illinois in that a divorce trial is a bench trial. That is, it is done with just the judge. There is not a jury. There are some states that still have jury trials for divorce in certain circumstances where you can request a jury trial. We used to have jury trials for divorce as an option. I wanted to say until the Illinois Constitution was amended in 1977, I want to say. And apparently jury trials went out at that point. We just have a bench trial. The judge is what they call the trier of fact and the decider of the legal issues. So the judge is the one deciding if people are telling the truth or not. They're sort of the judge and jury combined. A divorce trial is a rather dry situation. It's not very exciting. It's not like TV. It's not like the movies. Basically, it's two lawyers are sitting in the room. And the parties are in the room. So the spouses, the judge, the judge's clerk, and a bailiff. And usually that's about it. And there might be a witness who comes in to testify, not terribly often. A lot of people don't even have additional witnesses. A lot of times it's just the parties. And the witnesses are excluded from the courtroom, the other witnesses. The parties are allowed to stay for the whole thing, but witnesses who have yet to testify aren't allowed to sit there. The idea being they're going to hear testimony or questions from the lawyers and be sort of prepped for their testimony that way. So there's always a motion to exclude, which is to keep people out of the courtroom, and people who are going to testify are kicked out of the courtroom, have to sit in the hallway. So it's a dry situation, and usually it's about a lot of documents, and lawyers are asking the parties about all these documents, tax returns, bank statements, credit card statements, emails, and offering these things in evidence. And it's a very dry, boring process. I hate to break it to you. There are parts of a divorce trial that are probably nerve-wracking, I'm sure, for the clients. There might be sensitive issues people are talking about, but again, since we have no fault in Illinois, there's really no gotcha moments in these cases where it's like, oh, you cheated on me and here's the video. There's none of that. It's, what are your assets? So it's evidence of your assets, your debts, your income, expenses, and then people arguing how that stuff should be divided or how support should be set based on the law. And there will be disputed issues like, how should a business be valued if there's a business involved? Or somebody has a highly variable income. So figuring out what their income should be could be an issue. or there's a custody dispute where one person wants sole custody and the other person is fighting them on that. So it's just typically, it's not fun for anybody. It's very expensive, obviously, because the lawyers are putting in a lot of time. And the judge is listening to the evidence and looking at the documents that come into evidence. And Rahul, I think it'd be useful for you to describe a little bit about how evidence works. And what I mean, I don't mean the rules specifically, but the concept that, what can the court consider, and the idea of the judge looking through sort of a straw. If you can explain a little bit about the rules, just so people understand in our audience that, it's an unusual world, right? Like trial is a sort of an alternate reality, right?
Yep.
Can you explain a little bit about how the rules work just generally to filter information?
So the average layperson who contacts us, and then, eventually we have a case, and then let's say we go to a hearing or trial, they'll think, I have all these documents here that I want the judge to see. Or sometimes you'll hear someone saying, I'm going to email this to the judge. Or if you have some self-represented litigant, they'll say, I'm going to send this to the judge, and then say, Judge, I emailed this to you. Let me know your thoughts. It doesn't work that way. And that's what you're referring to, Raif, as far as how does evidence work. So evidence is both self-explanatory and not self-explanatory. Evidence is used to prove a certain point you are trying to make or establish a certain fact. And so there's lots of different types of evidence. There's oral evidence, testimony, there's documentary evidence, and then you also have things that you think are evidence, but you cannot have, the court is not allowed to see. Everything you have may be evidence, but everything you have may not be things the court can look at as evidence in a trial or an initial capture. To sort of the point is, what are the rules of evidence? Well, evidence and essentially admitting evidence in your case in chief is both a skill and an art form, and you really should know before going into it the documents you have and how you can get that into evidence so the court can see it. Now, what I mean by that really is that there are rules about how you can admit a tax return. You can't just tell the judge, here's a tax return. Please consider this as evidence of my income. Well, that sounds great. That's a very simple concept. However, there is a method of what they call offering it into evidence. It has to be authenticated. It has to be identified. There has to be sufficient foundation for the evidence. These are all legal words. And it cannot be hearsay. You have to make sure that it's the best evidence as well.
Just wanted to add the baseline concept behind the rules is to ensure that the parties are offering material that it's a fair play kind of situation. The idea is, does the evidence have some basic believability that the court could consider it? So first we want to know basically, where did this thing come from? Why should we even consider this? That's really what a foundation is. What admissibility of evidence is the idea that, what is this thing? Where did it come from? Why is it connected to this case? Why should we consider it? It's almost like a news article about the evidence. And it's exactly right. And so foundations are really the who, what, when, where, and why of a piece of evidence, whether it's verbal testimony. So when you want to introduce a conversation, you have to explain to the court first by asking questions of the witness. You can't just tell the judge, hey, listen to this conversation, and have the witness start just talking about a conversation. So it's like, you want to know baseline information. When was this conversation? Who was involved in the conversation? Who heard it? Who else was there? And then what did they say? There's any number of those baseline facts that you have to mention by asking the witness to testify to that stuff. And then once they testify to that, then you can introduce the thing, whether it's a piece of paper and you're building the foundation or the basis for offering the evidence. So the court is kind of saying, well, before you just hand me this piece of paper, why can I believe this? Where does this come from? Why is this worth even looking at? And that is what that's all about. So a lot of effort is spent at trials building those foundations and getting this stuff into evidence. And the concept is, the best way I've explained it to students in trial practice. I've done a lot of teaching of lawyers and law students, or actually college students in trial practice over the years. If nobody testifies that the sky is blue, or you don't ask the judge to take judicial notice that the sky is blue, it's not blue. In fact, it doesn't exist. Now, it sounds silly. I'm using a great kind of wild example, but like the parties to a divorce case, they know the whole world of facts about themselves and their children and everything. And there's a million things they want to say, but they can only say a limited number of things because of the way the rules operate. First of all, there's a time limitation because the judge isn't going to let you go on for weeks. But then there's the rules and then also relevance, which Rahul mentioned, and that is, how does this evidence connect to the issues in the case? And it needs to have some connection to the issues in the case for the court to consider it.
And I think it's very important what you said about the sky, because oftentimes, this is the judge typically who's been presiding over your case during this whole case when it builds up to trial. You don't file for divorce and then go to trial the next day.
Right.
It builds up to it, and trial is sort of the last resort because the two of you were incapable of settling the case for whatever reason. You can't settle if the other side doesn't want to settle. So that being said, you can't say, Judge, remember what happened 2 court dates ago. At a trial, a judge is a completely blank slate, an empty bucket. You need to fill that bucket with facts, and the other side will fill their own bucket with facts, and ultimately the judge is going to have to pick which bucket they like better. That's really how it ends up going. So if you don't tell the judge the sky is blue in your bucket, and they don't say that either, as far as the judge is concerned, there is no sky.
The only caveat I would give to that is what we've always talked about, the meta case that I talk about in my book, I Just Want This Done. The meta case is the judge's impressions. Those last through the entire case. And it's not in writing. The evidence is a clean slate, but the judge, of course, is a human being and is going to remember, like Santa Claus, who was bad and who was good. And that baggage, if you think that won't shade the outcome of a divorce case, you're dreaming. So what the guardian ad litem thinks of the parties or the people involved, and they're going to testify about their report, for example, in a custody case, what the judge thinks about the parties and their lawyers is important. And if you don't think that affects the outcome of cases, you're fooling yourself. So it's critical that people are aware of the meta case and the damage they can do to their meta case by being a jerk at some point in the process, or, there's a temporary hearing on some issue and somebody's unreasonable. So, for example, somebody cuts off the finances and doesn't, pay the bills when they were before, forcing the other side to file a motion for temporary support. When it's obvious, when it's a no-brainer that they should be paying support. Let's say it's a stay-at-home mom who has no way to support herself, and the guy's been paying the bills for 15 years. The judge is going to remember that guy was a jerk. And it doesn't need to be in writing anywhere. Any kind of issue that's on the fence, if you tell me that's not going to be impacted by the judges remembering that that person was not cool and did some jerky things to their spouse, you're wrong. So that's something to keep in mind.
I think you just hit the nail on the head, Raif. And that's why I classified it both as a skill and an art, because it's a skill, I think, to get it into evidence, but it's an art form to make sure that throughout the course of the case, like you said, the meta case, it's the attorney's job to hammer home the theme of the case. We want every case to have a theme and a theory. And you want the theme of the case to be, this is a person who cut off his wife from his finances, for example, using the example you just gave. And so as much as that's not evidence, that's not anything else, the judge will know going into it that, that theme is constantly in the back of the judge's mind as they view, that's the lens they view the evidence through. And so that's what's going to color their perception.
Yeah, and if you've got some more evidence that actually comes in the case of the person being dishonest or not truthful, maybe you impeach them by proving they told something that was false at a time or two, et cetera, that's going to then combine with the judge's previous impression to make the judge really believe that the lawyer's theme is correct. When we talk about theme and theory is the mechanical nuts and bolts of how this case works. So, I should get maintenance, or I should get alimony because my income is X and their income is Y, et cetera, right? The theory is the basic nuts and bolts of how the case unfolded, kind of like the whodunit part of the mystery. The theme is, like Rahul's saying, things like personal responsibility, truthfulness, these things. And in divorce cases, they revolve around things like personal responsibility and honesty and things of that nature. So if you can tie the theme into some actual evidence, and the person was a jerk previous to the trial and the judge is aware of it, that's going to ring true with the court and make them really tend to believe the stuff you're presenting. So that's where meta case is so powerful. And I devoted a whole chapter to it because sort of like it's something people don't, I think, talk about much and nobody put a name to. I've never seen anybody discuss it other than be nice, but not naming it as sort of a thing. And that's why I talked about it in the book and I wanted to mention it. So divorce trials, they typically, the simpler ones take a couple days. And when we say days, in our world, we mean afternoons. Judges typically spend the mornings doing ongoing other cases, doing motion practice and other things in the mornings, and then so they have afternoons free for trials. And unfortunately, in our jurisdiction, the trials tend to be chopped up into pieces unless they're shorter. So if they're bigger trials, you get like a couple days here, a couple days 2 weeks from now, a day a month from now, and they can go on for a long time, which is obviously very problematic. Some judges will try to do them contiguously and just do them one day after the next to get them done. But since they're bench trials, the judge judges can do this. With a jury, you can't do this because the jury sits on Monday and the judge wants to get the case done as soon as possible. So they're not inconveniencing a jury. So when I've done jury trials in my previous experience before I did divorce, the judges are in a big hurry to get the cases finished, and they're done day after day after day till they're finished. For whatever reason, in divorce court, it's chopped up into pieces usually. So in any event, it can take a long time to get these things done, and chopping it up into multiple days compounds the expense because your lawyer has to go back and remember stuff and re-prepare. So if it's been a few weeks, that lawyer is just a human being and they go on to doing some other things in the meantime. They have to get their wheels back under them before that next trial date. Okay, where are we? Where did we leave off? What do I have to work on? I have to get my head back in the game, and that takes time. So those are things that can add to expense in a divorce trial. So the only reason you should be trying a divorce case is you are diametrically opposed on some issue, or you've done that cost benefit analysis and you're confident that the cost in terms of time, money, and emotional energy is worth the potential benefit. Being really realistic about what you think the outcome would be.
And to summarize, right, a trial, we've talked about a lot about the mechanics and such, but a trial is where a judge will have the forum to listen to all the evidence to then ultimately make decisions relative to the outstanding issues in your case in order to resolve your case and then grant you your divorce. Now, a trial can be one issue, a trial can be every single issue. It doesn't matter. It's not an all or nothing thing where you say, if I'm going to trial, I'm going to trial on everything. Well, you could, but it doesn't have to be. You can stipulate, which is basically another word for agree. You can agree to 2/3 of your divorce and then say, this last 1/3, we are diametrically opposed, judge. So we want you to ultimately hear our respective positions, review our evidence, and then rule on who wins that issue or whose position is correct.
I can tell you, I wish more lawyers would stipulate to issues and certainly to admissibility of evidence because it would streamline so many trials. And unfortunately, what we've seen is the shark type lawyer will reserve agreement on issues that you would think were obvious because they want to put pressure on and they want to just say, well, we're not going to agree to anything. We're going to try all the issues. So you end up wasting a tremendous amount of time putting evidence in that everybody knows would be admitted, tax returns, bank statements, things like that. And the parties can agree to forego the rules, at least in terms of if they stipulate to evidence, to the admission of evidence. Stipulation means an agreement. A stipulation is magical. What that means is that document or that evidence becomes automatically part of the case. And the judge must consider it. Now, what weight the judge gives it, how important the judge thinks it is for the judge to decide. But there's no further need to ask those foundation questions we talked about. So you could have, for example, 100 bank statements and 3 years of tax returns. You could stipulate to the admission of all of that. You could hand it up to the judge, and the judge would later read it all, go through all of that material, or you're allowed then to argue those facts that are contained in those documents without any further proof, which can save a tremendous amount of time. Now, I've seen lawyers play nice in the sandbox about those things. And even in a hotly contested trial, there are a lot of documents you could stipulate to because the other lawyer is going to lay the foundation. They'll get it in. So you just shortcut the waste of time, and you can save a lot of time just by agreeing to the admission of a bunch of exhibits. Unfortunately, there are lawyers who won't do that. And then there are lawyers that won't stipulate to issues just because they want to be difficult. Maybe you think it's because they want to make more money, whatever. They think it's a leverage situation to say, fine, you won't agree? We're not agreeing to anything. I think that's a small-minded way to do it. Like Rahul, I'd prefer to stipulate to XYZ issues and let's just try issues A and B. That certainly makes the judge happy and the parties happy and saves everybody money and time. And we focus on only the things we disagree on. But it's, we're not the ones deciding how it all goes down. So there's two parties in these cases, and we can't control what the other people do. Trials typically take a tremendous amount of preparation. We tell people, figure for every trial day, figure 2 or 3 days of preparation. And for a rough rule of thumb, assume a trial day costs $5,000. I would just say just ballpark for time and preparation. Your mileage will vary in your jurisdiction, but it's not going to, it's going to be $3,000, something like that. It's figure 10-hour days for the lawyer, at least. The time it takes is tremendous. And then multiply that by 2 or 3 for the cost of preparation. And you see how expensive trials get very quickly. So hope that gives you all some perspective on this and some background. So now a word from our sponsors. This is my best-selling book. I just want this done. How smart, successful people get divorced without losing their kids, money, and minds. Available on Amazon, Kindle, Audible. I did the audiobook narration myself, and where all ebooks are sold. So if you do Nook or whatever ebook type you like, you can get it from all the different ebook providers. 300 pages. This is all the wisdom from my career and experiences of significant cases distilled into one book. And I tell client stories here with the names changed so that you can see real stories like yours and watch how they tie into lessons that I've learned over my career and things I've told my clients. And this book came from clients asking questions about divorce and my answering those questions based on my experience time and time again. And I thought to myself, I wonder if there's a book where these questions are answered and I could just, get these copies of this book for my clients and it would help them out. I couldn't find it. I looked high and low and I found books that said, hey, divorce is great. I found books that said divorce is terrible. I found books that said about how to beat up your spouse in divorce. I don't mean physically, but I mean like World War III, divorce lawyer basically recommending total war, all these combative things. It didn't cover the waterfront as far as I was concerned. These books missed so much. And there was so much I was telling people. They said, man, this is great. I appreciate what you're telling me. It's a little bit of common sense combined with my knowledge of the law. And I decided to just write the book myself, that out of frustration. That's where it came from. It was really a book written for our clients that I realized that other people might want to read. So it's been out since 2020, I believe. It's a bestseller still. People really enjoy it. So check it out. Also working on my second book called I Just Want to Know, How Smart, Successful People Decide on Divorce Without Fear, Uncertainty, and Doubt. And that's going to come out right around March 1st. That is going to help people figure out whether to get divorced and what's involved. So check all that stuff out. And also give us feedback, please, on the show. We hope you enjoy it. Let us know how we're doing. That gets us motivated to do more topics that you want to hear about and keep rolling with that. So next, we're going to talk about this Vox story. And this is sort of in the, dating and relationships and society section in the show. We talk about things like this quite often. This story got my attention because the title is How Divorce Him Became the Internet's De Facto Relationship Advice. And this is by Rebecca Jennings for Vox. And this was actually an October story, but I didn't know about it until when I was prepping for the show. And it says, most men are walking red flags, according to TikTok. So I thought the story was really interesting. And it talks about a person on TikTok named Lindsay Donnelly who she had a typical dispute with her husband about doing chores around the house. And to test him, she stopped doing stuff around the house for a couple of days. And of course, things like piled up and she videoed like dirty dishes and toys on the floor and that kind of thing and published it on TikTok and put it out there. And she got lots of comments like, you go queen. And then she started getting some kind of dark comments about how she should divorce this guy. And her husband, it went viral. Apparently, this is a year ago. She got 20 million views on this thing. People said things like, I'd get divorce papers. Honestly, that's unacceptable that he can't pick up as well. Don't let your husband stop you from finding your soulmate, honey. A lot of stuff like that, like pretty intense. And she said it really caught her by surprise. And she said, having people comment on my relationship and tell me to get divorced, I didn't feel good about that. And it felt sort of disproportionately painful. She said, you're going to hear the negative people tend to surface. And that's something we know from social media. Like it seems to be a place where people feel free to badmouth, and to jump on things. So people shouldn't be surprised that negative comments are going to follow, especially when people can be anonymous on the internet and their username is user12345. They'll say whatever they want. So,
and judging things in a vacuum.
Perhaps nobody said it better than Britney Spears, I'm quoting the story, who famously wore a t-shirt emblazoned with the words dump him in 2002 after her breakup with Justin Timberlake. Now, after subsequent events, I don't know if we want to use Britney Spears as a bellwether for society, but okay. Anyway, there's just a comment. The story basically says on any TikTok or Instagram reel posted by a woman that includes a male partner who looks anything less than ecstatic to be there, they're flooded with a variation of divorce him or a string of red flag emojis. In this article, the reporter interviewed a gentleman named Joseph Riegel, who's a professor of communications at Northeastern University, and apparently wrote a book called Reading the Comments, Likers, Haters, and Manipulators at the Bottom of the Web. He uses the metaphor of the rotten barrel, and it's the idea that the rotten apples can spoil the barrel, the concept that a couple of badmouthers sort of ruin and turn people sour and you tend to attract more negativity, which I think that makes sense. He says nasty comment sections can feel liberating for those participating in them. The gossipy nature of judging other people's relationships satisfies an urge to create narratives. People love a mystery. Yeah, and they love to be nosy. Let's be honest. everybody likes to see things fall apart for other people. Humans are very kind of nasty in that way because we want to feel good about our own lives. We got our own problems. And when we see somebody else having a problem, just human nature, it makes us feel better about our own. It's sort of human nature to dump on people like this, unfortunately. So it talks about this idea between, a lot of women, tends to be more women putting their relationship stuff out on TikTok, Instagram, things like that on video and showing tests of their man, like videoing the guy and asking him a question and kind of putting the guy on the spot to see how he reacts, to try to gauge if the guy's worthy of the relationship. And it's sort of funny because it talks about these tests. Like one of the most popular is the orange peel test, wherein you hand your partner an orange and ask them to peel it for you. If they do without question, they're a keeper. If they ask something to the effect of, why can't you peel it yourself? Run. Well, if you're using these internet trend tests to gauge a relationship, you're probably got bigger problems.
Well, and they're both on the opposite sides of the spectrum, right? Well, why can't you have something in the middle there?
Yeah, exactly. They mention other things. There's tests like the bird test, point out something tiny like a bird, see if your spouse responds enthusiastically. The Beckham test, which is start dancing to a song, see if they join you. And name a woman, in which you ask them to name a woman and hope they say your name. You said a woman, so if they say something else, I'm sorry, you guys aren't ready for these tests. To tie one thing in, though, this bird test, John Gottman's a famous relationship expert, and he's got all these books about marriage and how to make marriage work. And I was researching his stuff for my book, I Just Want to Know, which is coming out soon. But one of the things they talk about is bids. And bids are efforts in a relationship to get the other person's attention, no matter how small. So one example he gives in his book is, I guess where they do their therapy, they have a beautiful home that overlooks the ocean. And when the couple is sitting in the room for a period of time waiting, they'll be looking out at the harbor or this ocean. And like if one spouse says, hey, look at that sailboat. One of the things that's interesting is to see how the other spouse reacts. Like, do they say, oh, yeah, that's really nice, honey? Or do they just ignore them? And bids are efforts we make for connection between us and our spouse. And we do them in all kinds of ways, big and small, from saying, I don't feel good right now, or can you take out the garbage, or doesn't the dog look cute? Any of these things are things we do for bids. And what he talks about is in healthy marriages, they've measured statistics where in folks who get divorced, the bids are turned down much more often. And in healthy marriages, the bids are acknowledged in a very high percentage. So that's sort of like the bird test they're talking about here. So I thought some of this was interesting. What do you think about this stuff? And do you see these things on social?
Yeah, I've seen quite a few of these on social. I've seen a lot of those red flag emojis, on all the captions. Ask anybody. I think a lot of times those comment sections, those are always the best part about any of these posts, is to see what other people are posting, probably because you're curious to see other people's takes on these things. And then you have this idea of groupthink where everyone sort of just hammers home something that could even be a relatively innocuous, like, not being the most enthusiastic person about a bird because maybe the person was distracted with something else. And then so sort of using that to then say, all right, this guy has got to go, is feel like oftentimes a pretty big leap. Hard to judge people in a vacuum and reduce them down to a test on social media. There's obviously a lot of context. If this is obviously a pattern, maybe there's some further conversation you need to have with the person rather than seeing if they pass or fail a test and using that as the arbiter of whether or not you should divorce someone you've been with for 10, 15 years. Oh, sorry, you didn't peel my orange without asking me,
Right. This is just too much here to be letting a bunch of random people judge you on the internet and make some decision about your relationship. It's like, if your relationship needs to work for you and you alone and your children, There's a funny comment here about some guy named Dustin Pointer, known as the red flag guy on TikTok. And it's funny, I haven't come across this guy because I've been doing relationship and divorce content. I've got 24,000 followers on TikTok. I've been on there for 4 years and I've never come across this guy, but apparently he reposts videos of couples and with their relationship issues. I guess he runs with like a red flag if he thinks their relationship is in trouble, or a green flag if he thinks it's good. And so this guy has 4 million followers because of this stuff. He's a 32-year-old guy. He says, in his opinion, red flags aren't permanent. It requires a person to acknowledge it and want to change. Well, that's a good point. And he said he's not an expert. He's just a normal guy running with a flag through a public park who stumbled on a bizarre niche that allows him to live the life he always dreamed. Oh, okay. I just thought this was interesting and kind of spoke to something going on in the zeitgeist with this public audience thing people seem to be driven to, between filming themselves in the gym and then getting mad when people watch them, like a young lady in a leotard, or, yoga outfit, filming herself, hoping to catch guys watching her and then getting mad about it and making a big deal out of it. It's sort of that look at me stuff.
Oh, and then you looked at me, so now you're in trouble. It's like the cancel culture, right?
Yeah. But then it's like now doing it inside your own relationship, tripping your spouse up, and you're going to publish this online, maybe and maybe not with their knowledge or consent. I don't know. It seems like a road to trouble from this divorce lawyer. And the world needs more good marriages, not more divorces. So just thought this was sort of an interesting commentary on our society. So moving on, Rahul, I've got a couple listener questions. I purchased an investment property while married, and soon to be ex never wanted part of it before. He never contributed a penny or had any desire to put any time or effort fixing it up. It was purchased with investment partners and currently in an LLC. The deed was still in my name on the date he filed the petition for divorce. Should I be worried he could come after my investment property, or would he have to prove that he put money towards it? Assume no prenup.
And again, our caveat is always, your mileage may vary in your jurisdiction. This is all coming from Illinois law.
Right.
It's different in different jurisdictions. So in Illinois, one of the cardinal tenets of divorce law is the concept of marital property and the creation of marital property. And the law says that any property that you acquire during the marriage is considered marital property, with a few exceptions such as inheritances or gifts you might receive from third parties, etc. Things you come into the marriage with, so long as it hasn't been commingled, is often treated as non-marital property. So the baseline is the test of, was this purchased during the marriage? Yes. So is it marital property? Yes, unless you, as the person trying to show it's not marital, can prove it's not marital. So the burden is on you. The burden is not on him to prove it's marital. It's marital, unless you can show why it's not marital. Now, although it is marital, it doesn't mean automatically he gets 50% of it, especially because you have partners and it's in an LLC. The question becomes, what is the ownership share of each party? What is the level of contribution within that organization and the structure of how this is being held? Now, presume you have 3 partners and each of you owns a third. He would be entitled to a marital portion of your third, unless you can establish that even though you purchased this during the marriage, it came from funds you had before the marriage.
Well, that's a great answer. And this person's probably out of luck in terms of trying to keep it away from, or at least having a portion of this shared with their spouse. And typically what we'd see in this scenario is some kind of buyout arrangement, figuring out what this thing is worth, getting him, let's just say half of the value, may not be half, but could be half of the value, or trading debt or another asset to get the person bought out from this investment. But yeah, that's absolutely right. Okay, next question. I have several text messages. This is a juicy one. I have several text messages between soon-to-be ex and I that I'd like to use as exhibits and evidence in court for my responses and counterclaims. Do courts allow text messages to be used to show his character, parenting skills, inconsistencies, etc.? So for the purpose of this discussion, let's not worry too much about the particular issues in the case, because the person doesn't really get into that. But let's assume we're talking about, can we use text messages in general in a divorce case? Are they admissible? I would like you to address the character question, Rahul, because that's a valuable one to talk about. And then let's talk about the text messages related to parenting skills, because it is one issue they raise. And then I guess inconsistencies is worth mentioning too, after you talk generally about our text messages usable in a divorce case.
It's actually very poignant to the topic we talked about earlier as it relates to the and our brief foray to discussion of evidence. So you have to get it admitted as quote unquote evidence. Evidence of behavior doesn't mean they're evidence a court would admit. And so you have to lay the foundation for the text message, why it's relevant to the issue at hand. And you have to object to that. The court will then say, yes, they'll sustain the objection. And so the question becomes why, and that's where we kind of go further into the question, which is to show character, parenting skills, inconsistencies, etc. But it depends on why you're trying to establish his character. Example, if it's are married for 2 years, no kids, the only thing you have is some property to divide, and you want to put into evidence text messages to show his character, you think he's a bad guy or you think he is a very nice person to you, the court may not let you get those text messages into evidence because there's no relevance to the division of property. The law is pretty clear about, marital misconduct not being a factor in dividing financial assets. So may not be something you can get into evidence because, again, his character in that one issue is not relevant. But now his character and tying into his parenting skills, show that he is untrustworthy, not dependable, doesn't show up, doesn't know how to take care of the kids, so on and so forth. And you have text messages that establish that. He says, I'm lost here. I need your help. I can't watch these kids without your help. I have no idea what I'm doing here. You have a text message from him that says that, and you can establish that he sent it, when, where, what was the context. You can go through that and you can get that in. As long as you can establish it's not hearsay, which you have to get over that hump, then court may let it in. And similarly, inconsistencies is the third prong, which is, okay, he said one thing in court, but now you have a text message from him saying the exact opposite yesterday or 2 days ago. And now you can clearly show that he's lying, or he's either lying then or he's lying now. So you can impeach him. That is to show prior inconsistent statements, which would be this text that you would still have to admit for purpose of showing that what he is testifying to in court today is not what he said to you 2 days ago or said to somebody else 2 days ago. So in that case, also, you could probably get that text message in. So yes, courts allow text messages to be used. It depends on why you're trying to use it.
Right. And also the stuff has to be, the best way I can explain it is it has to be important. A court's not going to let you try this case with 4,000 text messages. And also like self-serving messages, like it says, I have text messages between me and him. Well, if it's your own statements and you're just saying you're a bad guy or you're terrible at parenting and you're trying to admit your own statements. He said, well, he didn't respond to it. So it means he's admitting it. The court's not going to admit that stuff. If it's a bunch of self-serving stuff that your own statements, the court's not going to be interested in. Like Rahul said, if it's admissions by the other guy that he's constantly refusing to take him to the doctor, or you've requested multiple times that he agree on a counselor and the messages back say, I refuse. Okay, now you've got some evidence that's admissible and has relevance and some weight. A court's not going to allow just a ton of text exchanges where he sort of looks like a jerk. I call that bad guy evidence. It's the character evidence everybody wants to put in that the courts don't allow, which is just what I call dirtying up the guy. You're just trying to make him look bad. The court's not interested in that. Like Rahul said, it's got to be something material and connected to the issues in the case. So if the issue is he's a lousy parent or he's dangerous, then you need some text messages to that effect, and not self-serving ones that just you wrote, but stuff they admitted to or they published in a text message. Now you're talking. So we got a little technical, but these communications between spouses are a little more tricky. Whether it's a text or an email or a handwritten letter, it's all the same. The standards of proof are the same. The foundations are really the same. So a text message isn't magical in and of itself. Obviously, these days we communicate a lot by text, so they can become significant. And we do have people screenshotting these things and admitting some of them in divorce cases. Thanks for the question. We always appreciate them, and they help us help other people who have similar questions out there who just don't ask them. So thank you. And thanks a lot. That's it for the show. We appreciate you listening. Like, follow, share, subscribe to this podcast on your podcast player so that the system knows you like this content and you'll get more of it as the episodes drop. You'll keep getting notified about more of them. And please review the show, especially on Apple Podcasts. We really appreciate it. And reviews on YouTube help us understand that you like this content and want more of it. So thanks very much from Rahul Iyer and I, Raif Palmer. Have a great day. Thank you.